Good afternoon, everyone. Welcome to week 5 of our international law journey. We're rapidly getting through the semester, so we're nearly halfway there, which also will mean a mid-semester break quite soon, which I'm sure is very exciting for everyone listening in, as well as your teaching staff. So we will be getting to that quite soon. And possibly by the time you are watching this lecture, you have either submitted your assignment, your first assignment, or you're in the final preparations of doing so. So I hope that the submission has gone well and that also the final preparations for your assignment is also going smoothly if you haven't quite submitted it yet. Just like I mentioned always in class and also in previous lectures, please just send me an email if you need any assistance or guidance with your assessment. I'm very happy to set up a consultation if you need as well, because I know in our tutorials we don't always get enough time and certainly not a lot of one-on-one time. So please just reach out if you need any assistance with your assessment or any other questions otherwise. So today we are going more into the architecture of the international legal system, the actual foundational structures of it. And one of the central institutions at the heart of our international law system is the International Court of Justice. And the International Court of Justice, or the ICJ, is one of the main topics of examination in this lecture. And we do this on the background of trying to understand a bit further the requirements that states have to seek a peaceful resolution to their disputes. And a primary mechanism in the way in which they do that is through court processes at the ICJ. So we will start this discussion, this lecture, with a bit of an overview of the general examination of the obligation of states to pursue peaceful means of international disputes. And then we'll primarily focus on the ICJ. And again, like I mentioned in all our classes, I really want to supplement the material that you read in your textbook. So and recommend once again approaching the textbook chapter first on the peaceful settlement of disputes, reading through that, and then engaging with this lecture because I think it will then hopefully supplement a bit further, concretize and build more on what you have read in the textbook. So again, my aim is to give you a more well-rounded overview in some of these more crucial topics. I don't have as much time as the textbook does to go in every small detail, but I do my best to focus on points that I think are particularly relevant for our general understanding of international law and also maybe might need a little bit more elaboration that the textbook might not quite get to. So this is, again, the aim of these lectures. And then when we do talk about the ICJ, we'll particularly be focusing on the jurisdiction of the ICJ, sorry. So we'll be asking, when can the court hear a case? What is the contentious jurisdiction of the court? What is the advisory jurisdiction of the court? And then what is the effect of an ICJ decision? So these are the main questions that I'd like us to try to grapple with today. And I mean, one of the kind of issues, I guess, that we have in talking about this topic now in our course progression is that we actually deal with the United Nations in week 9. So in quite a number of weeks from now. And it is slightly unfortunate. I mean, there is a good reason for this structure, but it is a bit unfortunate because the United Nations kind of gives a grounding to this whole topic. And so most of the discussion that we'll have is implicitly connected to the United Nations. Luckily, many of you will have some familiarity with the United Nations, or in abbreviation, UN. But we will explore this preeminent international organization in much more detail when week 9 comes along. During the lecture, I will be discussing the UN relatively frequently, as well as the United Nations Charter, and also relate the ICJ function and its role to the broader purposes of the United Nations. But at this stage, just know that the United Nations exists. It's out there. It's something we'll deal with, and also has a charter. And I promise we'll have a really in-depth examination of the United Nations and its kind of institutional mechanisms, alongside the General Assembly, the Security Council, and other bodies of it. So I promise we will be dealing with that topic at a later date. But for now, just we have to park that in our minds a little bit as we then get more specifically into peaceful settlements of international disputes. So I'll try to move my slides again. Here we are. So this is what we're trying to do today. So look, like I mentioned, we're looking at the general obligation on states to peacefully settle their disputes first. Then a lot of this is then focused on the ICJ. So what's the jurisdiction of the ICJ? What's the effect of the decisions? And in class, we'll also look at a few different examples too. And then we will critically assess how the court has justified the exercise of its jurisdiction. And these last two will really be more what we'll be doing in tutorials, where the first four is more focused on the lecture as well as the textbook too. So now let's get into it. Broadly speaking, in terms of peaceful settlements of disputes. Now, let me see if I can. There we go. Sorry. I feel really bad because I like to think I'm quite technologically competent, but there's so many things that shows that I'm not. One of them being I have never been able to work out, despite it was 5 years since the pandemic and we've had to use Zoom a lot more frequently. I've never worked out how to remove, and you probably see this in your viewing, the little gray boxes that are around my screen. I mean, I hope you're not seeing them and what I'm talking about now just doesn't make any sense to you, which is great. But I do have a feeling that you can see the little gray boxes in my screen. And I make sure it doesn't actually inhibit the content. But despite the life of me, I haven't been able to, and I've tried a lot of how to, remove them. I've got a certificate 3 in multimedia too. So, I don't know. So apologies if it interrupts anyone's enjoyment of the lecture. But anyway, let's get into peaceful settlements of dispute. Now, again, we're not dealing with the UN today, but it's enough to know at the moment that one of the major purposes of the United Nations, and this is again backed into the history of this major international organization, which we'll get to. One of the major purposes is to bring about by peaceful means and in conformity with principles of justice and international law, the adjustment or settlement of international disputes or broader situations which might lead to some kind of breach of the peace. And so member states of the United Nations, not just the United Nations organization itself, undertake to settle their disputes by peaceful means, and in a way that international peace and security and justice are not endangered. So this is an obligation on the member states themselves as a part of the UN, and the UN has this broader purpose. And importantly, for the UN Charter, Chapter 6 is devoted entirely to the peaceful settlement of disputes. And it goes through and specifies the roles of various United Nations organs and by the the means by which parties to disputes may seek a solution to their contentious issue. And according to the UN Charter, the obligation to seek a peaceful settlement applies to any kind of disputes which, if they continued, may be likely to endanger the maintenance of international peace and security. So this could be this could and is very broadly defined. So disputes that immediately threaten peace, like an armed conflict, or involve a breach of the peace or an act of aggression, may be subject to these provisions of Chapter 6, as well as Chapter 7 of the Charter. And again, we will talk about them in a lot more detail in week 9. But this obligation to seek peaceful settlement also extends to disputes where there is not yet a direct threat to the peace. So it's quite preemptive. Okay, it's not just when violence per se is broken out. It's even disputes where there may be the potential for that disruption down the road. And these disputes, whose continuation or continuance may not be said to endanger international peace immediately, these should also be settled as harmoniously as possible. Um, but if there's disputes or disagreements of like between states, which is just of kind of like a technical nature, and they still enjoy friendly relations with each other, that might not fall into this category of disputes which the UN Charter is concerned about. So it's mainly concerned about two situations where there's an immediate violence, whether through aggression of the state or some other breach of the peace, or a situation where the continuation of which may lead to some kind of violent outcome. So these are the two main areas that the UN Charter is concerned with, and the UN broadly as an organization. Now, the means of the settlement of international disputes are set out in Article 33, subsection 1 of the UN Charter. And it says that the parties to any dispute, the continuation of which, and I'm quoting here, is likely to endanger the maintenance of international peace and security, shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. So there's a lot of options on the table, and we will be touching on a few of these as you can see in the slide. And like I mentioned, this obligation to pursue peaceful means to settle international disputes is central to the purposes of the UN as an organization, but also central to the regime of the UN for collective security, which is also one of the major purposes of the organization. But this also sometimes exists in tension with the principle of state sovereignty. We've spoken about this before. Previously, when the kind of precursor to the ICJ, and we mentioned this institution as well, the Permanent Court of International Justice, or the PCIJ, in its advisory opinion on the status of Eastern Karelia, it recognized that a consequence of the sovereign equality of states is that no state can, without its consent, be compelled to submit its disputes with other states either to mediation or to arbitration or to any other kind of pacific settlement. Okay, so the right of a state to determine whether it will submit an international dispute to arbitration or judicial determination has hampered the potential role of the UN, as well as its other institutions like the International Court of Justice and other international tribunals in settling disputes and also developing jurisprudence. So this obligation to settle disputes is in contradistinction somewhat to state sovereignty, because if states don't want to settle things peacefully, then they might argue their sovereign right to kind of do as they please. And this kind of reluctance of states, and it doesn't always happen, but if there's the kind of reluctance of states which may persist when they're reluctant to consent to dispute settlement through international tribunals or to even bring applications against other states. This also means we have a reduced jurisprudence, which means there's a lack of judicial authority to kind of explain international law. And that was really quite the case for a number of years until relatively recently, where there has been more engagement with forums such as the International Court of Justice. And so there has been an increase in case law. So now let's talk about some of these peaceful methods. So the first one on the screen here is negotiation. And negotiation also includes other descriptions of this process, such as consultation and exchange of views. And this is the primary means by which most disputes between states are settled. And the fundamental kind of character and universal acceptance of this like method of settlement has been acknowledged by the courts. So acknowledged not just by the ICJ, but also previously by the Permanent Court of International Justice, or the PCIJ. Uh, and so this is a common, I guess, means of peaceful settlement. But the fact that states who are in a dispute are engaged in negotiations doesn't preclude their resort to other means of settlement. So just judicial procedures. So if two states are having a negotiation, that doesn't mean they can't use other means of resolving the dispute. And for example, what comes up relatively commonly are judicial procedures. So there's no general rule of international law that negotiations must be, or the possibility of negotiations must be exhausted before other means of settlement may be employed, which is very different, I believe, to other domestic laws. For example, in Australia, where for some disputes there has to be some kind of mediation between parties, but this isn't a requirement as a general rule anyway. But there are some treaties that do provide for an obligation of prior consultation before states can act. Um, and treaties may also specify that you need to have some kind of consultation or negotiation as a means of settlement of some dispute, or as a preliminary step to other means of settlement before states can resort to judicial determination, for example. So in some treaties, there may be this obligation, but often this obligation to negotiate doesn't actually mean there's an obligation to reach an agreement. Okay, so it's just an obligation, if any, in treaties sometimes. It's just an obligation to negotiate, not to actually get a negotiated outcome. Then, in certain treaties again, if negotiations do fail, then sometimes treaties will direct the parties to go to third-party methods of settlement, conditional on this failure of negotiations. But also, this obligation to negotiate can be actually imposed by judicial decision. And the ICJ has made such orders regarding the delimitation of the continental shelf, the decisions on where territorial seas begin and end, decisions on the nature, form, and amount of reparations, fulfillment of treaty obligations, and also in finding equitable solutions between states. So the ICJ does have the power to do that, and has done so in the past. And also, we haven't spoken about this institution yet, but we will in week 9, the Security Council may also urge parties to negotiate as well. So negotiation is a time-honored way of settling disputes, which often parties are directed to do either by their treaties that they may be in, potentially by the international courts, or even by international bodies such as the Security Council themselves. Now, turning to mediation and good offices, this usually refers to, again, this just because I have this list here, it doesn't mean that you kind of states follow these methods one after the other. But still, having said that, when negotiations do fail, or they kind of stagnate and they can't progress anywhere, often this second method kind of occurs or is suggested. And typically a third party will intervene, and they will offer to try to settle the dispute. And this is mediation. And so mediation at a baseline is defined as the participation of a third state or states, or a disinterested individual who's not involved in it, or perhaps a UN organ, in some attempt to reconcile the different claims of the parties, and advancing proposals to find some kind of compromised solution. Whereas and quite similarly, good officers means that in a very narrow sense, that the good officer who may be mediating does not themselves make proposals on the substance of the dispute. Um, so like offering some kind of suggestion. But this is more maybe what you might see in mediation. So good officers is almost a little bit broader than mediation and is usually used uh, uh, in a sense equivalent to mediation, but it's probably more distinguishable by the fact that the third party acts to initiate or kind of tries to continue negotiations um, uh, in mediation without actively participating in the discussion of the dispute. So I mean, the classic good officers is, for instance, like a third party, and it comes from this, like, have my good officers for, um, talking through your dispute. It's kind of forum for you to use. And so the third party won't like make suggestions. They won't kind of try to drive the negotiations forward. Whereas mediation is more of that direct process where they actually try to get the parties along. It's a little bit more interventionist. Now, both of these forms, mediation and good officers, are identified as means of dispute settlement in lots of different treaties. Um, and they require the consent and cooperation of the parties to the dispute, especially since usually the proposals of the mediators are non-binding. And like I mentioned, both mediation and good officers can be carried out by individuals, states, or even several states at once. Now, turning to our third one here, the fact-finding inquiry. This idea of the inquiry can be understood in a couple of different senses. Firstly, it can be seen as a process which is performed to resolve a disputed issue of fact. And this may form part of an arbitration process or conciliation or even a judicial settlement. Whereas it could also refer to a specific institutional arrangement, which is generally known as a commission of inquiry. So some treaties do provide for inquiry and fact finding as means of dispute settlement. Um, so if a dispute is about where someone's control of the sea may be, then a fact-finding inquiry might help the parties factually resolve that question. But parties can also establish commissions of inquiry on an ad hoc basis, or whenever they would please. But usually, individual states haven't used these mechanisms on a widespread scale. But the United Nations has made frequent use of these commissions of inquiry. And the UN has engaged in lots of fact-finding missions really regularly to provide an objective account of the interests of the parties to a conflict or to a dispute, or even to undertake like a broader examination of peace and security challenges which may impact lots of different state members. And this fact-finding mission by the UN may be a means to enable the political organs, as well as the Secretary General, who is the figure of leadership of the United Nations, as we'll talk about in week 9, to gain a better picture of a particular situation or broader situations, so they can decide how to exercise their powers under the UN Charter. So again, something we will come back to in week 9 and also touch on in subsequent weeks, where it does kind of cut across a few different areas of interest that we'll be looking at. Now, conciliation, our fourth one on the list here. This involves a commission which is set up by the parties, and I guess like they're set up by the parties, which might be on a permanent or ad hoc, as needed basis. And the idea is that these conciliation kind of commissions impartially examines the dispute, attempts to define the terms of a settlement which is susceptible of being accepted by the parties, or it provides aid to the parties with a view to move along to settlement. So, comparing it to arbitration, which we'll touch on soon, and the proposals of this conciliation commission are usually non-binding. But it will, and generally it's set up to contain several different members. But it is possible to have a single counsellor or conciliator consider disputes. Um, and kind of in distinction to previous peaceful methods we've spoken about, bilateral treaties providing for some kind of settlement of disputes. It's a bit rarer for them to refer to conciliation. But it is more common in multilateral treaties on lots of different topics that they can and often do provide conciliation, often in conjunction with other methods of settlements. And states have been known as well to create ad hoc commissions when they're needed to address specific disputes. But in most cases, these conciliation commissions will determine their own procedure, and there has to kind of help commissions as they're set up. There has been a number of model rules which have been created by several different bodies to help guide these conciliation commissions, and including the General Assembly have done that as well. Now, in terms of the regional level, and in addition to being mentioned in Article 33 of the UN Charter, the role of regional agencies or regional arrangements in the peaceful settlement of disputes are also referred to in Article 52, subsection 2. So these regional arrangements and the architecture at a more regional level are seen as really important components of the peaceful settlement of disputes. And so these different regional arrangements or agencies are included among these peaceful settlement of disputes under Article 33 to provide member states with the option to apply the other means which have been mentioned so far. So like our negotiation, mediation, good offers, fact-finding inquiries and so forth at a regional setting. And there has been lots of examples where regional organizations have contributed to the peaceful settlements of disputes through providing members with a forum for consultation and negotiation, and by the provision of these so-called good officers. And the European Union, for example, includes in its constitutive instrument, its founding instrument, cooperation with the UN. So some regional organizations have set themselves or tried to place themselves within the broader architecture of the UN and the peaceful settlement of disputes. Some regional organizations have developed formal structures for negotiation, mediation, and conciliation. And the UN has also partnered with regional actors, either jointly or in supporting them in mediation efforts as well, and has also received cooperation from regional organizations in the provision of good officers. And especially since the mid-1990s, the UN has had often high-level meetings between itself and regional organizations in the field of conflict prevention and peace building, especially when that, like the so-called peace building industry became a much more important part of the UN international architecture. Now, finally, for our peaceful settlement of disputes, and also just like I mentioned last week, team, for these slides, I do try to include, because I know they're quite text light, I do provide notes within the notes section. And what I'm actually going to probably do moving forward now is print that, or we'll put it up on your canvas as a PDF so you can like see the notes there, because I think I've spoken to many of you about this, and I think quite a number of you didn't realize that they were there. So I'm going to try to make them a little bit more obvious going forward. So I'll try to put a few key points which speak to some of the broader areas that that I speak on in these lectures. So finally, arbitration and judicial settlement. Um, this this is kind of like a determination of a dispute between states through a legal decision, and this is usually a decision of one or more persons chosen by the parties on the basis of respect for law. And this is arbitration. This is what we know as arbitration. And the procedure generally results in some kind of binding decision on the parties to dispute, which distinguishes it, like I mentioned, from conciliation. But unlike judicial settlement, which we again will expand a lot more on when we talk about the ICJ, arbitration is usually constituted by mutual consent of the state, the states involved to a specific dispute. And the parties retain quite a lot of control over the process because they appoint arbitrators of their own choosing and also determine the applicable law to their disputes. And arbitration is another instrument that we see quite frequently in bilateral and multilateral treaties. And it's one of the means which are frequently chosen to settle territorial and boundary disputes. And as well as concerning the interpretation of treaties and claims of violation of international law. Now, state parties to a dispute may seek to also submit their dispute to a pre-constituted international court or tribunal composed of independent judges who settle claims on the basis of international law and whose decisions are binding on the parties. Now, the only court of general jurisdiction is the International Court of Justice, which is also the principal organ of the United Nations, the principal judicial organ of the United Nations, which is what we will now consider in some more detail. So the International Court of Justice. So now I have put in the slides this diagram showing the relationship between the UN organs. Again, I realize we haven't spoken yet in detail about the United Nations General Assembly or the Security Council, but it's good to keep this framework in mind when we do get to those topics in week 9, because it will help us situate the ICJ quite a bit here. But also some of the points that I'll be discussing does touch on these bits of information and these connections between these United Nations institutions. Now, the International Court of Justice, or at least like the idea of some form of international justice and effort, continuing efforts to achieve it, has actually been around for a very long time, not just in the more modern embodiment of the institution, the ICJ. Even from the Middle Ages until the 19th century, it featured prominently in a lot of quite purely theoretical plans for a European or even a world federation. So theorists such as Pierre Dubois, Jeremy Bentham, and Immanuel Kant, among many others, anticipated this kind of like European or global federation where there would be a judicial branch or some kind of system of arbitration which should settle disputes that had some kind of legal nature or other complexity. And the idea was that if the main evil in international society, and especially after international society so-called emerged after the Westphalian Peace, as we spoke about in week one, if the main evil after Westphalia was the excessive presumption of sovereignty, as many theorists and authors thought, the solution then must be to limit the reach of sovereignty by the device of some kind of power that embraces the whole world. Um, and by entering into a federation, states would relinquish these excessive sovereignties. Again, which is really problematic around this time because states were in constant conflict with one another. And they would give up their sovereignties in favor of a centralized power. This would then, again, as the theorist kind of justified, this would eliminate rivalry between sovereignties because there'd be just one sovereign now. The federal world body, there'd be only one sovereign subject with no possible competition from outside. And this would also ensure that international society would be transformed into one in which the rule of law prevailed. So the idea from a lot of these classical and what are called classical liberal theorists, the leap was from the politics of their time and the violence and the war that they saw it created to an apolitical law. Um, and in the 19th century, and kind of away from the thinking of these early theorists, there were several processes that helped uh, move the global political system away from necessarily strict interpretations of national sovereignty. Um, the As was kind of dawning at that time more and more starkly, the realities of growing interdependence of countries with increasing globalization on one side and the destructiveness of war on the other. And the waging of war is like the ultimate sovereign right of states. Political forces during this time, throughout the 19th century, looked for some kind of novel solutions. Um, and they uh, thought or hoped to organize international society to better control and police these forces, which threaten to always spiral the world into various uh, conflicts. Um, and during this time, there had been a turn towards a lot of arbitrations and arbitral practice. Many states decided to resolve disputes between or among themselves by recourse to a nominated arbitrator or to a college of nominated arbitrators as well. And an attempt was made to provide some kind of general regulation for arbitration to facilitate its use for those states who are willing to resort to it. And this was one of the objects of the Hague Peace Conference of 1899 and the follow-up conference of 1907. The aim of the 1899 conference was to create a framework for optional arbitration. And it did so at this time by providing a set of rules that provided for the immediate operation of arbitration only if the states in the dispute wanted to. And this is when the Permanent Court of Arbitration, or the PCA, was set up. And we don't go into the Permanent Court of Arbitration all too much, and this is kind of the only kind of commentary we have on it. And it wasn't really permanent in the sense of like constantly being there or like a standing tribunal, always accessible, but it did operate through it had a permanent secretariat where states could select arbitrators from a list and then constitute a tribunal when they wish to do so or ad hoc. But with this move towards arbitration in the late 1800s, it quickly became apparent that it wasn't really enough. It was insufficient. By the 1907 Hague Peace Conference, or the follow-up to the Hague Peace Conference in 1907, many states actually wanted the establishment of some kind of permanent court which had compulsory jurisdiction in certain subject areas. And I guess, quite surprisingly to now, it was the United States that put forward a proposal, a very bold proposal for the creation of a new permanent court alongside this permanent court of arbitration. And the idea was that this court would be a standing entity, supported financially by all state parties who may sign up to the convention, and ensure representation of various legal systems. And it'd be composed of professional, non-removable judges, and also hold regular sessions. And the US was actually drawing from its own history in proposing this court, because it had also started in the United States in the mid 1700s. It started with a court of arbitration, and then 10 years later, it established its Supreme Court. But the proposal at the time in the early 1900s, the US's proposal was defeated, and it was mainly because it was impossible to get some kind of consensus on the composition of the court. It was a very political and fraught subject. But after World War One, opinions started to shift. The time started to be ripe, especially because of the huge destruction of the war. The unimaginable, chaos and loss of life had opened the way for bolder intrusions into state sovereignty and equality, which had always been the stumbling blocks of trying to get the court off the ground. And the establishment of the League of Nations produced some kind of form of world governance for arguably the first time. And it was obvious at this time that the body should have some essential features of a public organization, with a political executive organ, a democratic assembly, and importantly for us in this discussion, a court of justice. And so in Article 14 of the League of Nations Covenant, it gave the League Council the task of preparing a draft proposal for the Permanent Court of International Justice. Then in 1920, the council turned this project to a committee of respectable jurists to get it set up. And really, even though the interwar institutions are often rubbished and a little bit fairly too, the Permanent Court of International Justice, or the PCIJ, was actually quite remarkably successful in terms of its activities. It delivered 32 judgments on jurisdiction or admissibility and merits, all of which were actually implemented, though not always without a considerable amount of difficulty. And out of its 27 advisory opinions, many of them were also acted upon. But the court did have a very cautious and conservative stance in its contentious cases, but then also had a bolder, you might say, progressive jurisprudence in its advisory functions that dealt with the powers of nascent or early international institutions. And this kind of balancing of judicial caution in the contentious areas and some more judicial activism in the advisory opinions did seem to be a good mix, because the court was relatively accepted by states and also other international institutions. And it enjoyed actually quite a bit of prestige throughout the 20s and the 30s, which we can't really say the same thing for the League of Nations. Now, after the Second World War and the horrors that accompanied the Second World War, the question then arose as to which course to steer the Permanent Court of International Justice. Should we? The question was like, should we keep this alive, this Permanent Court of International Justice, or should it be dissolved, replaced with something new? And the I mean, at the time of thinking here, the PCIJ was closely connected conceptually with the League of Nations, and I mean, in reality too, is closely connected with the League of Nations, even though it was a lot more successful than the League of Nations. Um, but it was not actually a formal organ of the League of Nations because it was intended to enjoy full independence. And so, after World War II and the awful horrors of that war and the failures of the League of Nations, the PCIJ was kind of lumped in with those international failures. And so the decision was to actually dissolve the court and create a new one. There's some interesting history here, which we can't really go in too much detail in the lecture, unfortunately. But yeah, it's quite interesting. But the new court that came out of the ashes, it held its inaugural meeting in 1946, and on the same day that this inaugural meeting was held, the final League of Nations Assembly was held to dissolve the League and the PCIJ. And these previous institutions were given a farewell. Um, but even though the International Court of Justice was technically a new court, um, and there was that seeking of creating a division between the PCIJ in the past and the ICJ going forward, there was actually a lot of stress on the continuity with the old court, and this kind of goes towards the jurisprudence. And we'll see this in many ICJ cases that the ICJ will often still look to PCIJ decisions as well, which is important. Now, in terms of the court in the UN system, this is relatively unique, and this is the International Court of Justice now we're thinking of. We've kind of gone through the history, and now again, we haven't spoken a lot about the UN yet, but I'll try to situate where it is in the UN system, and we'll fill in those blanks in week 9 as well. So the ICJ is not a political organ, and so it makes it quite unique, and it enjoys full judicial independence. It may not receive instructions from the political organs like the General Assembly, the Security Council, in respect of particular cases it deals with, or to its judicial policy. And importantly as well, Article 92 of the UN Charter says that the statute of the court, which is something we will go into more detail soon, it says it forms an integral part of the present charter. And this particular Article 92 is quite important because firstly, it means that the statute of the ICJ and the as well as the UN Charter are covered by the Operation Article 103 of the United Nations Charter, and that article says that in the event of a conflict between the obligations of the members of the United Nations under the present Charter and their obligations under any other international agreement, their obligations under the present charter shall prevail. And so this provision then, 193, applies not only to the primary law of the charter and the ICJ statute, but also to secondary law derived from these texts. So the decisions taken by organs on the basis of the charter or the ICJ statute. So obligations which come from a decision of the Security Council under Chapter 7 of the Charter enjoy precedence over obligations arising under another agreement. And then obligations arising out of decisions of the court enjoy the same precedence as well. So the other second important point of that Article 92 of the UN Charter that says the statute of the court, the statute of the ICJ forms an integral part of the UN Charter is that it must be also read in conjunction with the next article, Article 93 subsection 1, which says all members of the United Nations are ipso facto parties to the statute of the International Court of Justice. So by ratifying or acceding to the UN Charter, a state automatically becomes a party to the court statute. So a state cannot become a member of the UN without also accepting its judicial institution and its statute. But it's also important to note, though, that that doesn't actually necessarily mean that it doesn't mean that the state who is coming to the UN accepts the jurisdiction of the court for contentious cases. This acceptance only flows from separate acts. Now, let's talk about the ICJ bench and its procedures. And we won't go on this too long because it is covered quite well in your textbook, and it's not super crucial information either. But the bench of the International Court of Justice consists of 15 judges, each being of a different nationality. And the nomination of a judge is made by a national group, and that judge is then entered into elections. And these occur simultaneously in the General Assembly and the Security Council. So the veto which is enjoyed in the Security Council by the major powers does not apply to the election, and only a simple majority is required in both organs. And a judge may get this dual simple majority early, or it might take lots of different rounds of voting for the necessary dual majority to be received. And as there will also usually be other elections happening, and because fewer than the five judges may secure the necessary majority in both organs, because every 3 years, the number of seats that become vacant are five judges. So these are the ones who are elected, or the number of seats elected every 3 years. But these elections can be complicated because there is some kind of like understanding to the and kind of informal understanding to the regional distribution, and as to the tradition of electing candidates who come from the permanent five Security Council countries. So this isn't obligatory. Like, states don't have to follow this kind of understanding. As to having candidates from the P5 on the bench. But this idea of having like a regional balance in the judges has been a norm that has kind of set up since the 1960s. And it's supposed to kind of mirror the regional composition of the Security Council. So in addition to the P5 seats, there's usually a Eastern European seat, two Western European and others seats, and this other seat is usually a rotation between like a Northern European and a Southern European seat. There's usually two Latin American seats. One may go to a Caribbean candidate, three African seats. And usually one will be Anglophone, one will be Francophone, reflecting both like a common law and civil law background. And then the third of the African seats is usually North African. And then there'll be two Asian seats as well. And previously, some Middle Eastern countries have been considered in the Asian seat, with Jordan, for example, having been considered an Asian seat. So a judge from the Middle East will fill one of the Asian or even the African seats as well. And then other countries like Canada, Australia, New Zealand, they are usually subsumed within the category of Western Europe and others. And so these judges are elected for a 9-year term. Like I mentioned, there's 15 of them, but these judicial elections are staggered. So only 1/3 of the court comes up for re-election at any one time. And there's a lot of politics, in these elections. I obviously can't go into it too much, but a candidate who seeks election or re-election will normally think it, courteous to be present once or twice at the UN. Coming up to an election period, they'll meet representatives of states and also answer any queries they may have about the court. It's seen as a polite form of behaviour, not for the states to directly question or challenge in an overt sense how a judge has voted on particular cases. But it is, it is a political process. And in reality, judges face a lot of different pressures. And the judges have reported quite frequently that there's often pressures from states, other states, as well as their own national authorities, depending on, how they have voted in contentious cases, especially. Now, the court is a principal organ of the UN, as we've said. It's principal judicial organ. And so it has its seat in The Hague. And the idea is that it's supposed to have some kind of convenient distance from the politics of the UN in New York. And the rules that govern the function of the court, which we'll touch on in some more detail soon, these are kind of in four layers of text. So you have the Charter of the UN, the statute of the ICJ, the rules of the court, and the practice direction. And each layer has its own kind of function. So the Charter sets out matters of general interest for the UN. The statute contains the really important rules for the functioning of the court, and this is what we'll focus on next. The rules contains the really procedural details, and the practice directions are quite new and there to give kind of practical advice to parties, especially with that general view of trying to resolve practical problems, and speed up the procedure in what is usually quite a lengthy procedure as it is. Now, the Charter and the statute, so the UN Charter and the ICJ statute, they're not in a hierarchical relationship. And so Article 103 of the UN Charter does not refer to a hierarchy between the Charter and the statute. Any conflict arising between them should be resolved by interpreting the norms under consideration. But the conflicts haven't actually really arisen much on this point. But the ICJ statute is in effect the constitution of the court. It sets out, the central rules for its operation. It can be modified or altered, but only by the parties to it, because they're the masters of the treaty. But the court doesn't have the same function or the same freedom. It can't modify it itself. It must respect the statute in all circumstances, because this is the founding text that provides the basis on which the court exists and operates. So when the court adopts the rules to regulate the details of its procedures, they must be compatible with the statute. And this is also the same for the practice directions as well. They must conform with the statute and the rules. So there is some kind of hierarchy there between the rules of the court and the practice directions. They must conform with the statute itself. Now, Chapter 14 of the UN Charter is what is devoted to the International Court of Justice, and it contains 4 articles dealing with matters of the Court of General Interest to the United Nations. I'm not sure if I have this on my next slide or not. Oh no, I go in a little bit more detail there, but I mean, maybe I'll flip back to. So the UN Charter, we have Article 92. We mentioned that it establishes the court as the principal judicial body of the UN, and then Article 3 deals with being a party to the statute, and we've mentioned that all members of the UN are ipso facto or by default parties to the statute. And then Article 94 continues with an important point, and it's stated that each member of the UN, in subsection 1, undertakes to comply with the decisions of the ICJ in any case to which it is a party, and to the extent that the court has issued an order or a judgment containing an obligation to that state. And then subsection 2 of that article then addresses if a state fails to comply with the court judgment. The Security Council may be called upon to take measures to enforce that compliance. And according to an interpretation of Article 94, subsection 2 of the Charter, the Security Council could even take forcible measures without having to determine a threat to the peace. So it's seen somewhat as a basis for this kind of action. And then Article 95, it says that the court is a subsidiary mechanism for dispute resolution, and it's based on agreement or choice. So it says that states can have recourse to any type of procedure for peaceful settlement of disputes. The court has no automatic superiority or preference. So there is not a monopoly or preference for adjudication by the court, which is not the case in like domestic courts, for example. Um, so the important point is that the dispute is channeled through some kind of settlement procedure. It doesn't matter if it goes to the court or not. So now, sorry, I'm now back on the right side. Let's talk a little bit more about the ICJ statute itself. And I promise, the important points I'll also put in the notes too. And I've mentioned before that the ICJ statute is annexed to the UN Charter. So it's divided into 5 chapters, as I've noted there. Looks at the composition or organization of the court, its competences, jurisdictions, the procedure, advisory opinions, and then amendments. So I'll just give a brief overview of some of these and a little bit more detail of some more important ones. Like, for instance, chapter 1, I won't go into really any detail about because it's about a lot of the overview I've given just in the slide before about the composition, the organization, how judges are elected and the rules of procedure. Chapter 2, which is about jurisdiction, is actually quite a bit shorter than chapter 1, but it's really fundamental in terms of the importance of it as it deals with the jurisdiction of the court in contentious cases, which is our disputes between states. And it sets up that the court is involved in 2 distinct sets of proceedings. So we have on one hand contentious proceedings, and this is the typical proceedings of the court where it'll hear a dispute between a couple of subjects or states and try to resolve this dispute by a way of some kind of binding decision. And then on the other hand, the other proceedings chapter 2 sets up are advisory proceedings. So the court is asked here a legal question by an authorized organ of the UN, and it will then give its legal advice in a reasoned opinion, and it won't be legally binding on the requesting organ. So these are the 2 distinct sets of proceedings the court or is regulated by chapter 2 of the court. And in chapter 2, only the contentious proceedings is kind of strictly regulated. And so articles 34 and 35 concern questions of jurisdiction, ratione personae, so personal jurisdiction, and we'll come back to this. Articles 36 and 38 concern aspects of jurisdiction, ratione materiae, or jurisdiction over subject matter. And again, we'll come back to that. So in the contentious proceedings, the chapter 2 talks about what are the persons that we can have jurisdiction over, or persons we can have jurisdiction over. What is the subject matter? And these are points we will touch on kind of right at the end, I guess. Now, Article 34, subsection 1, contains one of the most fundamental rules for these contentious proceedings. And this goes to this personal jurisdiction, which we'll unpack in more detail soon. And it says that only states may be parties in cases before the court. And so this is really important. It's really fundamental for the structure of the court. It emphasizes that, yes, the ICJ is an interstate organ. And it makes clear that states have a monopoly over the contentious procedures. So an entity must be a state, and also a party to the statute or authorized in some capacity to appear before the court, in order to be a claimant or a defendant, before the court. So it also imposes a limitation to its jurisdiction of the ICJ in terms of the so-called persons or who can be parties, or the entities that can be parties, and their states. But this has been criticized by authors, and especially after the Second World War. Many critical authors have said that the access to the court is too restricted, and that the statute should be revised to be more in line with modern international law. and also kind of the realities of international relations too, where the state is not the only subject of, firstly, like international law itself, and also not the only important subject. Now, Article 36 of the ICJ statute looks at one of the aspects of the jurisdiction over the subject matter or the ratione materiae, and this is the consensual jurisdiction of the court. And so this is a peculiarity of international justice, which isn't the same in our domestic courts, where the court has no compulsory jurisdiction in the proper sense of a compulsory jurisdiction. It doesn't automatically extend to all states that have ratified or acceded to the statute or are otherwise entitled to appear before the court. In order for the court to have jurisdiction, there must be further consent by all litigating states to accept the court's jurisdiction. This consent can be given in different ways, and Article 36 talks about that in a little bit of detail. But without some kind of consent by the parties in a case, the court lacks jurisdiction and will decline to decide a case on its merits. So in this sense, the litigation before the court is kind of always optional. And when we look at court cases, cases the ICJ, one of the first questions they deal with is jurisdiction, because they have to deal with, well, can we even consider this point? And then as a final point for this chapter, Article 38 also concerns that subject matter jurisdiction in terms of, well, what is the law the court has to apply? And it says in the first subsection that it's emphasized that the court's mission is to decide disputes according to international law. And then it goes through the sources of international law that can be considered. And this corresponds with the main sources of international law and customary law, which we've spoken about previously. I think in week 1 or 2, perhaps we looked at the sources here. So, it talks about the agreements, our treaties, our customary international law, and also general principles of law as well. And just like we also mentioned that judicial decisions, including of the ICJ itself, are not binding international law precedents, and we've spoken about this before, and outside the context of the states who are parties to those proceedings. So there's no rule that the court has to follow its previous decisions in international law. A judicial decision is usually persuasive on its merits. The judge will typically only discard it if there's a good reason to, or the law's changed, or if the present judge is convinced that the previous judge was in error. But in practice, you will see that this quite rarely happens, and the court is usually quite anxious to follow its own precedent, especially when it's dealing with a lot of very vexing, contentious issues, that it is quite anxious to ensure it's following its own precedents and pointing to its way of doing things as being followed. Now, Chapter 3 is concerned with procedure. And there's not a lot in this chapter in terms of the actual procedure, because a lot of it is the more nitty-gritty is spelled out in the rules of the court. And the idea is that these rules should be able to be changed flexibly. So Chapter 3 doesn't actually put down a lot of hard and fast rules, because they should be able to change if they need to be. Probably of importance, I'll just touch on a couple of sections here. Article 41 is concerned with the important matter of provisional measures. So these measures are included by the court in an order in the case of urgency. So their object is to preserve the rights of the parties pending some kind of final decision. And we've seen this in recent cases where the court has given a provisional measure to quickly to protect the rights of the parties in some urgent cases. And the respondent state cannot take advantage of the period before delivery of the judgment, of the final judgment, to devalue the potential rights of the other parties. Because if this was allowed, the final judgment could be deprived of all its kind of utility. So the court specifies provisional measures to prevent the dispute from being aggregated. For example, if there's in danger of further military incidents, or if there is a danger for treaty or convention rights to be infringed. And we saw this also most prominently in the recent case where South Africa brought Israel to the court, to the ICJ, for arguable or accused breaches under the Genocide Convention, and the court gave a provisional measure in that case. Now, Article 55 affirms that if the judgment does not represent in whole or in part the unanimous opinion of the judges, any judge is entitled to deliver a separate opinion. And the power of any individual judge to append to the judgment a separate or a dissenting, doesn't have to be dissenting, but it can be a separate one. This was a concession to the Anglo conception of common law, where the kind of continental conception of this approach to the law was that a court judgment should always be presented as like the common opinion. And the choice of the ICJ to allow individual opinions was actually inserted in the statute of the PCIJ. And so the view at common law, as we're probably all familiar with, is that a judgment is a series of collected and eventually converging learned opinions. And at the ICJ, there's a majority decision which forms the judgment of the court as voted upon, but the statute allows the addition of separate opinions. And again, in pretty much most of the cases that we have put in the required readings, it's worth having a look at them. In terms of on the website of the ICJ, you'll often see there's the order, and it'll have the different languages of the order, and then there'll be a number of different opinions, and even on the advisory opinion on that we looked at last week concerning the separation wall in the occupied Palestinian territories. If you have a look at that, and that's from July 2024, if you have a look at that judgment, there is pretty much every judge has put in a separate opinion. And it doesn't necessarily mean that always dissenting. You'll actually see, for instance, in that case, Judge Crawford, who is one of the authors of the textbook that we use here, an Australian judge, she puts her own separate opinion, and it's not dissenting, but she wants to add some more detail to certain questions around like self-determination, which her honor found particularly important. So, and that's a really good example to see that done in quite a widespread way. And and Article 55 allows for that to happen. Now, Article 59 states that the decision of the court has no binding force except between the parties in respect of that particular case. So that's something we've mentioned before. So this has like a positive and negative side. So negatively, it kind of puts away the notion of that court judgments have a binding precedent. It only fixes the law as it is between parties to those proceedings, but positively, it is binding to those parties in the proceedings. So they should, they have to implement it. As an Article 94, subsection 1 of the UN Charter recalls that. So Article 59 is like an obligation to implement. And the way that is done, it doesn't really interest the statute or international law. The state is quite free as to the means of implementation, but it supposes some kind of action or maybe implementing legislation. So there's a duty there on states to actually follow through. Now, Chapter 4 deals with advisory proceedings, and this is quite peculiar for a court of justice. So certain organs of the United Nations and affiliated agencies can request legal advice from the court on a question that arises within the scope of their activities or competences. And this legal advice is supposed to be from the court, is supposed to be authoritative, but it's not binding or executory. And Article 96 of the Charter provides a general answer as to which organs can request an advisory opinion. Number one, the General Assembly of the Security Council, and number two, other organs of the United Nations and specialized agencies which may at any time be so authorized by the General Assembly, so they have to actually be authorized, may also request advisory opinions of the court on legal questions arising within the scope of their activities. And so this provision concerns jurisdiction around ratione personae materiae, which we'll touch on shortly. The organs who are entitled to seize the court and the scope of the questions they're able to ask. This jurisdiction and admissibility of requests in advisory proceedings rest on a series of different requirements. I won't go on these in too much detail, but maybe just to say that in their advisory opinion on the jurisdiction or their statements around jurisdiction in the nuclear weapons case and the Kosovo advisory opinions, the court recalled that its jurisdiction rested on being seized by some kind of duly authorized organ on a legal question falling within the scope of the activities of that organ. And so this personal jurisdiction is concerned with the request by that duly authorized organ. Can be the General Assembly, can be the Security Council, or some other body that is authorized by the General Assembly. So this is an important point to note. Now there's 3 points, and I think maybe I'm getting near the end of the time I have for this, but there's 3 points to note concerning the legal and political effects of an advisory opinion. That first, the opinion delivered by the court is not binding on the requesting organ, and it's not binding on the states whose dispute is indirectly made the subject of the opinion. It doesn't have like an operative part, and it's not judging a matter finally either. But it is just rendering an opinion on the typical legal or political questions, or legal questions involved, which often always has some political ramifications. Now, and the second point is that beyond the legal duty to take account of the opinion, there is a further legal effect of such an opinion, which is often kind of not addressed a lot by the scholarly academic literature. That an opinion is binding on the UN organs as regarding a point of law decided by the court's jurisdictional act. So to the extent that such organs are obliged or deliberately choose to adopt a legal solution to a point settled by the opinion, that point of law becomes binding on the requesting organ. So international law is binding on the organs of the UN. So when the court has made a finding as to the law, they cannot actually ignore it. And finally, some advisory opinions have binding legal force, and this binding nature is not derived from the opinion itself, but what flows rather from collateral acts or collateral legal acts. So provisions containing treaties or rules which attribute to the court's opinion a binding legal effect in a particular situation or context. So there's actually a number of international treaties which provide that the court's opinion will be binding on the requesting organ, and sometimes even on the parties to an underlying dispute. Now, just very briefly, the Chapter 5 talks about amendments to the ICJ. It's a really cumbersome procedure. It only succeeds in very rare cases. You have to get 2/3 majority of the states of the UN General Assembly to adopt an amendment. An equal majority must ratify it. And in this majority, there must be the 5 permanent members of the UN Council. So it's a difficult one to do. But these all the different layers of documents that govern the court's activities are really well drafted. They've stood the test of time. And there hasn't been a whole heap of change in the ICJ statute, for example. And obviously, I haven't been able to go into the rules and practice directions much here, but they're not really something we need to worry about for our purposes in our international law course. They're just for your interest to know that they're there. Of course, if you interact with these organs in more formal occasions after your studies, then they obviously become a lot more important. Now, as a final point, and I really think I'm getting near the end of this, so sorry for going a bit long here, but the jurisdiction is important. And I have spoken about jurisdiction in some length. And this goes towards the case of who can seize the court, who can what cases can it hear, and these kind of things. And like I mentioned, the ICJ has to deal with this question of jurisdiction in all of its cases. So it will always be up and front center of the cases that it deals with, and they have to be examined before issues of admissibility. Um, and so the court has to satisfy itself that it has jurisdiction before it expresses a view on really anything related to admissibility. So jurisdiction is always dealt with first. And so typically, the court may be still asked to examine the admissibility of a claim as a question of the existence or non-existence of an admissible dispute, which talks about like the prior negotiations between parties, whether a alleged dispute is or is not an actual current dispute, the existence of the necessary standing to take action, and many other things. So only sometimes the issues of admissibility kind of trounce issues of jurisdiction. But I mean, for all intents and purposes, jurisdiction is like the main thing that the court will deal with. And there's three types of jurisdictional questions. The first relates to the scope of personal jurisdiction. To whom or over persons can the court have jurisdiction over? The second relates to the material jurisdiction, with what subject matter is the court competent? And then the third relates to international tribunals and consensual jurisdiction. Have the states agreed to the competence of the court? This agreement is necessary to take into account that idea of state sovereignty. And if all three aspects of the jurisdiction are present in a given case, then the court has jurisdiction to decide the dispute on its merits. Now, in terms of these three, I'll just briefly touch on ratione personae and materiae mainly, but also quite briefly, because I have spoken them about in the context of the ICJ statute. And I mentioned is Article 34, subsection 1, that deals with this idea of ratione personae, that states are parties before the court. And that's kind of the main thing we need to worry about, really. Now, ratione materiae is a little bit more complex. And I mean, and this is kind of more in terms of contentious cases. So, and ratione materiae, or thinking about the subject jurisdiction, is made up of two aspects. The first one is the existence of some kind of dispute, because the context of the court is it's there to resolve disputes. It's not there to make historical inquiries, give some kind of political advice, make legal suggestions, or anything else. It has to determine with regards to some kind of contentious dispute. And a dispute, what is a dispute? This was defined by the PCIJ in a way that still remains relevant today, and the ICJ still refers to that definition, sometimes altering it slightly, and I'm quoting here: a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between two parties. And that's the first element of the subject matter jurisdiction. So this dispute, the second aspect, it must be of a legal nature. And it, in principle, must be of a nature that the court is required and can apply international law to it. So a dispute is legal in nature if the claim or counterclaim, as well as the defense, are submitted by parties on grounds of the law, so that they're formulated in some kind of legal terms. So no dispute is inherently or by nature legal or political. A political dispute can be legally formulated. So in the context of a treaty or a broad legal principle, such as an abuse of rights, or a legal dispute can be formulated on the basis of policy considerations. So if a change in the legal position by new legislation is put in issue. But the test is always the subjective formulations of the claim. So if a party claims to have a right, a duty, a power, or a privilege under the law, and it formulates claims on this basis as against another party, then it's a legal dispute. This isn't based on some kind of particular subject matter or some kind of objective factors. It's based on the way in which a case is presented, on the ground on which it is intentionally or voluntarily based. So when two parties in dispute and we call it, they seize the court, so they, engage the court by some kind of special agreement, um, which this kind of is the material in determining the legal character of the dispute. So I mean, that's all we're going to touch on for the jurisdiction. I mean, there's obviously quite a lot there, and we've gone into quite a bit of detail as to, oh, that's what I should have put up, sorry, I've reproduced those two slides, my mistake. But, they're the main points that we need to know about in terms of jurisdiction. It's really just, the questions that you'll have to grapple with is, can the court judge or give an opinion on this particular question? Is the personal jurisdiction, is the subject matter jurisdiction present? Is there consent? These are the important things. Now, in week 5, we're going to be trying to apply these in class. Which will hopefully be a bit of fun as well. And I really look forward to seeing you then. Thank you very much again for tuning in. Get in touch if you have any questions at all. And thank you very much, everyone, and talk to you soon.